Listen to me carefully because what I'm about to share with you might bring you peace during the hardest time of your life, and it could save you from paying thousands of dollars you never truly owed. I'm Charles Wellington, and I'm 72 years old. I've been practicing elder law for 38 years. But 5 years ago, something happened that changed everything about how I understand grief and money. I lost my wife, Eleanor. We were married for 47 years. 3 days after her funeral, while I was still numb, still going through the motions of each day, the phone call started. Credit card companies, medical billing offices, collection agencies, all of them saying the same thing. Mr. Wellington, we're very sorry for your loss, but we need to discuss your late wife's outstanding balance. I'm a lawyer. I've spent decades protecting widows and widowers from financial exploitation. And even I felt that moment of panic, that whisper of doubt. Maybe I do owe this. Maybe I'm responsible for her debts. That feeling, that fear, that's exactly what these companies are counting on. They call you when you're broken, when you're too tired to think clearly, when you just want everything to stop hurting. And they use words like estate responsibility and spousal obligation to make you believe you have to pay. But here's the truth I learned both as a lawyer and as a widower. In most cases, you don't owe your spouse's debts, not legally, not unless your name is on the account or you co-signed the obligation. Let me tell you about Dorothy. She's 68 years old, a retired librarian, and she called me 6 weeks after burying her husband of 42 years. She was sobbing. She'd just written a check for $18,000 to pay off her husband's credit card debt, money from their savings account, money she needed to live on. They said I had to pay it, she told me. They said, as his widow, I was responsible. I asked her one question. Dorothy, was your name on that credit card account? No, she whispered. It was just his, for his business expenses. My heart broke for her because she didn't owe that money. The debt collectors had lied to her, and she'd paid $18,000 she didn't legally owe because she was grieving, confused, and afraid. Dorothy is not alone. Every single day, newly widowed people across America are being pressured to pay debts they don't owe, fees they don't owe, and bills they don't owe. Companies target them during their most vulnerable moment, knowing that grief makes people compliant. But today, I'm going to stand beside you. I'm going to walk you through 6 common financial traps that widows and widowers face, 6 charges and debts that companies will try to make you pay, but that you don't legally owe. And I need you to stay until the end because the last one is the most manipulative. It's the trap they set when you're planning the funeral, when you're too heartbroken to think about money, and it costs families an average of $8,000 to $12,000 they don't need to spend. So grab a notebook if you can, or just listen closely. And if any of this sounds like something you're facing right now, please know you're not alone and it's not your fault. Don't forget to tap that like button so this reaches more people who need to hear it, because this information could save someone from financial devastation during the worst time of their life. Now, let's begin with the most common and most aggressive financial trap widows and widowers face. When Margaret's husband Thomas passed away after a brief illness, she was 71 years old and had never managed their finances alone. Thomas had always handled the bills, the credit cards, the bank accounts. 2 weeks after his funeral, Margaret received a call from a credit card company. Mrs. Henderson, we're calling about the outstanding balance on your husband's Visa card. The current balance is $14,280. We need to arrange payment. Margaret's hands shook. I don't know, she said. I wasn't on that account. It was just his. Ma'am, the caller said firmly, you were married. You benefited from the purchases on this card. And as his surviving spouse, you have a legal obligation to settle this debt. Margaret believed them. Over the next 3 months, she made payments totaling $14,280, draining a significant portion of the savings she needed to live on. But here's the legal truth Margaret didn't know. Unless you co-sign the credit card account or you're a joint account holder, you are not personally responsible for your deceased spouse's credit card debt. Not in any state in America. This is fundamental contract law. A credit card agreement is a contract between the card issuer and the person who signed the application. If only your spouse's name is on the account, only your spouse's estate, not you personally, may be liable for the debt. Now, here's where it gets important. The estate means the assets your spouse left behind. If your spouse had individual assets, like a solely owned bank account or individually titled property, those assets might need to be used to pay the debt before being distributed to heirs. But you, as the surviving spouse, are not personally liable. Creditors cannot make you pay from your own separate property or income. They cannot take your paycheck. They cannot take your retirement account. They cannot force you to sell your home if it's in your name. From my work with widows and widowers, I've seen this trap destroy people financially. One woman I helped had paid over $32,000 on her late husband's credit cards over 2 years, money she desperately needed for her own living expenses, before she finally called me. When I asked to see the credit card agreements, not one had her name on it. Not one signature was hers. We stopped payment immediately. The credit card companies backed off the moment I cited the law. Here's what you need to do if you receive calls or bills for your deceased spouse's credit card debt. First, ask yourself, was I a joint account holder or was I only an authorized user? There's a huge difference. A joint account holder applied for the card with the spouse and signed the agreement. An authorized user was simply allowed to use the card but never signed the contract. If you were only an authorized user, you have no legal obligation to pay. Second, request written verification of the debt. Ask the creditor to send you documentation showing that you personally guaranteed the debt. If they can't provide your signature on the original credit card agreement, you don't owe it. Third, send a written letter stating that you are not personally liable for the debt and that all future communication should cease. Send this via certified mail. Fourth, if the creditor continues to harass you, contact an attorney or file a complaint with the Consumer Financial Protection Bureau and your state's Attorney General. Deceptive debt collection practices are illegal, and creditors who lie to grieving spouses face serious penalties. And fifth, if you've already paid money on a debt you didn't owe, you may be able to recover it. Consult with an attorney about your options. Emotionally, these calls are devastating because they come when you're at your weakest. The callers use your grief, your confusion, and your fear against you. They know you want to do the right thing and honor your spouse's obligations. But let me say this clearly. Protecting yourself from illegal debt collection is honoring your spouse. Your spouse would not want you financially destroyed paying debts you don't legally owe. You can do this too. One letter, one firm boundary can stop these calls and save you thousands of dollars. Coming up next, we'll talk about a debt that sounds more official, more governmental, and that makes people even more afraid to question it. When Robert's wife, Linda, passed away after a year-long battle with cancer, the medical bills had already been mounting. She'd had surgery, chemotherapy, radiation, hospital stays. Medicare covered some of it, but not everything. 3 weeks after Linda died, Robert started receiving bills. $4,800 from the oncologist, $2,400 from the hospital, $2,200 from the imaging center, all addressed to him, all demanding payment. Robert called Medicare. They told him they'd paid their portion. The rest was patient responsibility. Robert assumed that meant his responsibility. He started making payments, $500 here, $300 there, draining his retirement savings month after month. But here's what Robert didn't understand. In most states, you are not personally responsible for your deceased spouse's medical bills unless you specifically signed a financial responsibility agreement guaranteeing payment. This is critically important. In community property states, Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin, the rules are different. In those states, medical debts incurred during the marriage may be considered community debt, and the surviving spouse may have responsibility. But in the other 41 states, medical debt is individual unless you signed something making it joint. Simply being married doesn't automatically make you liable. Now here's the trap. Hospitals and medical providers often have family members sign admission paperwork that includes financial responsibility clauses. The language is vague, the forms are long, and you're focused on your spouse's health, not the fine print. But if you didn't sign such an agreement, you're not personally liable. The medical provider can make a claim against the deceased spouse's estate, but they cannot come after your personal assets. I helped a widow named Patricia who'd been making payments on her late husband's $23,000 hospital bill for 8 months. When I asked if she'd signed a financial responsibility agreement, she didn't know. We requested the documents from the hospital. They couldn't produce her signature on any financial guarantee. We stopped payment. We sent a letter explaining she was not personally liable. The hospital never contacted her again. Here's what you need to do if you receive medical bills for your deceased spouse. First, determine if you live in a community property state. If yes, the rules are more complex and you should consult with an attorney. Second, if you don't live in a community property state, request copies of any financial responsibility agreements from the medical provider. Ask them to show you your signature guaranteeing payment. Third, if they cannot produce such an agreement, send a written letter stating you are not personally liable for the debt. Cite your state law. In non-community property states, you can reference common law principles that debts are individual unless jointly incurred. Fourth, if the provider continues to bill you or threatens collections, file a complaint with your state's attorney general and consult with an attorney. And fifth, be very careful about making any payments on these bills. In some states, making even a small payment can be interpreted as accepting responsibility for the debt. From an emotional perspective, medical bills feel different than credit card debt. Medical care kept your spouse alive, or at least tried to. Refusing to pay feels like dishonoring their memory or being ungrateful for the care they received. But here's the truth. You can be grateful for the medical care and still protect yourself from financial exploitation. These are not mutually exclusive. You can do this too. One firm letter asserting your rights can eliminate tens of thousands of dollars in medical bills you don't legally owe. Next, we'll talk about a situation that combines grief with financial manipulation in the cruelest way possible. When Helen's husband George died suddenly of a heart attack, she was 73 years old. They'd been married for 51 years. Everything they owned was joint: their house, their savings account, their checking account. 2 months after George's death, Helen tried to withdraw money from their joint savings account to pay her property taxes. The transaction was denied. She went to the bank. They told her the account had been frozen due to a creditor claim against George's estate. Helen was terrified. "But this is our money. We saved this together for 50 years. How can they freeze my account?" The bank representative gave her a sympathetic look. "I'm sorry, Mrs. Phillips. When there's a claim against an estate, we have to protect the bank from liability." Helen sat in that bank lobby and cried. She had bills to pay. She had $47,000 in that account, money she and George had saved, and she couldn't access a penny of it. But here's the legal truth. In most states, assets in a properly structured joint account with right of survivorship automatically pass to the surviving spouse outside of probate, and creditors of the deceased spouse generally cannot reach those funds. The key phrase is "with right of survivorship." Most joint bank accounts are structured this way. It means that when one account holder dies, the other automatically becomes the sole owner. The funds don't go through the estate, and estate creditors don't have a claim to them. Now, there are exceptions. If the account was funded entirely with the deceased spouse's separate property right before death, specifically to avoid creditors, that might be considered a fraudulent transfer. But for accounts that couples have jointly maintained throughout their marriage, the funds generally belong to the survivor. The problem is that banks don't always understand this, or they're overly cautious and freeze accounts whenever there's any question about estate liability. And grieving spouses who don't know their rights simply accept it. I helped a widower named James whose bank had frozen a joint account containing $83,000. The account had been joint for 34 years. I sent the bank a letter citing state law on joint accounts with right of survivorship and demanding immediate release of the funds to James as the surviving account holder. The account was unfrozen within 48 hours. Here's what you need to do if your joint account is frozen after your spouse's death. First, verify that the account was a joint account with right of survivorship. Check the account agreement or ask the bank for documentation of the account type. Second, if it was a proper joint account, the funds are yours. They're not part of the estate. Send the bank a written demand to release the funds, citing your state law on joint accounts. Third, provide the bank with a death certificate and proof of your identity. That's all they should need. Fourth, if the bank refuses, contact a lawyer immediately. You have the right to access your own money, and the bank's unauthorized freeze could be illegal. And fifth, for the future, understand how your accounts are titled. Joint accounts with right of survivorship protect the surviving spouse. Accounts in only one spouse's name go through probate and may be subject to creditor claims. Emotionally, having your bank account frozen is terrifying. Money represents security, especially when you've just lost your life partner. Not being able to access your own funds creates panic, but you have rights, and banks must follow the law. You can do this too. One firm letter asserting your ownership rights can release your funds within days. Now let's talk about a debt that sounds governmental and official, which makes people afraid to question it. When Dorothy's husband Frank died, the family home had been in his name alone. They'd bought it 40 years ago, before Dorothy understood the importance of joint titling. Frank had always paid the mortgage and the property taxes from his personal checking account. After Frank died, Dorothy received a notice from the county tax assessor. Property taxes were due, $6,800. The notice was addressed to the estate of Frank Morrison. Dorothy panicked. She didn't have $6,800 and she wasn't even sure she owned the house anymore. She called the tax assessor's office. They told her the taxes had to be paid or the county could place a lien on the property. Dorothy scraped together the money and paid. But here's what Dorothy didn't understand. The property taxes were a legitimate obligation, but they were an obligation of the property, not of her personally. And as the surviving spouse, she had rights to the home, even though it was solely in Frank's name. In most states, surviving spouses have homestead rights or statutory rights to the marital residence. Even if the house was titled only in the deceased spouse's name, the surviving spouse typically has the right to continue living there and, in many cases, to inherit it outright, depending on state law and whether there was a will. Now, property taxes and mortgage payments are different from credit card debt or medical bills. These are secured debts or obligations attached to the property itself. If they're not paid, the county can place a tax lien or the bank can foreclose on the mortgage. But here's the key: you're not personally liable for them beyond the value of the property. If you choose to keep the house, you need to pay the taxes and mortgage to protect the property. But if the house isn't worth keeping, you can walk away and creditors can't come after your other assets. I worked with a widow named Sarah, whose husband had owned a heavily mortgaged rental property in his name alone. The property was worth $180,000, but the mortgage was $210,000. After he died, the bank demanded she continue making payments or face foreclosure. Sarah felt obligated, but when I explained that she wasn't personally liable for the mortgage and that the property was underwater, she understood she had choices. She could let the property go into foreclosure without personal liability, or she could try to negotiate a short sale. She chose to let it go. The bank foreclosed, and Sarah's credit wasn't affected because her name had never been on the loan. Here's what you need to know about property taxes and mortgages after your spouse dies. First, property taxes must be paid if you want to keep the property, but if you can't afford them, contact the tax assessor's office immediately. Many counties have deferral programs, payment plans, or exemptions for surviving spouses. Second, if there's a mortgage on the property, you need to contact the lender right away. Under federal law, the Garn-St. Germain Act, lenders cannot enforce a due on sale clause when a property transfers to a surviving spouse. You have the right to assume the mortgage or continue making payments. Third, if you're not on the mortgage or property title, you'll need to go through probate or use your state's spousal transfer procedures to get the property legally in your name. But you can usually stay in the house during this process. Fourth, if the property has more debt than value, consult with an attorney about your options. You may not want to keep it, and that's okay. You're not legally required to take on debt that exceeds the property's worth. And fifth, if you're struggling to make mortgage payments, contact the lender about loan modification, forbearance, or other loss mitigation options before you fall behind. Emotionally, the family home is often the most precious asset a couple owns. It's where you raised your children, where you built your memories. The thought of losing it is devastating, but you need to make financial decisions based on reality, not emotion. If keeping the house will destroy you financially, it's okay to let it go. You can do this too. One honest conversation with yourself about what you can afford can save you from years of financial struggle. Coming up, we'll talk about debt that comes wrapped in family obligation and guilt. 3 months after burying her husband, Patricia received a visit from her brother in law, Tom. They sat in her kitchen, and Tom said gently, Patricia, I know this is a hard time, but before Mike died, he borrowed $15,000 from me to help with the business. I never mentioned it because I didn't want to stress him out while he was sick. But now that he's gone, I need to talk about repayment. Patricia was stunned. She'd never heard about this loan. There was no written agreement, no documentation, just Tom's word. But Tom was family. He'd been kind to her during Mike's illness. She felt obligated. Over the next year, she paid Tom $15,000 in installments from her limited savings. But here's the question I would have asked Patricia. Did this loan actually exist? And even if it did, was she legally obligated to repay it? The answer to both questions is unclear without documentation. And that's exactly the problem. Personal loans between family members or friends are incredibly difficult to enforce legally because they're rarely documented properly. Even if the loan did exist, unless Patricia co-signed or guaranteed it, she's not personally obligated to repay it from her own funds. The debt, if legitimate, would be a claim against Mike's estate, but Patricia, as an individual, has no obligation to pay it out of her separate property. I've seen this scenario play out dozens of times. A family member or friend approaches the widow or widower with a claim of a loan, often months or even years after the death, when memories are fuzzy and documentation is non existent. Sometimes the loans are real, sometimes they're exaggerated, and sometimes, sadly, they're completely fabricated by people who see a vulnerable widow or widower as an easy target. I helped a widower named Edward, whose late wife's sister claimed she'd loaned the couple $22,000 for a down payment on their house 15 years earlier. The sister demanded repayment now that Edward was selling the house. Edward felt terrible. He thought, maybe this is true. My wife handled those finances. Maybe I owe this. I asked the sister for documentation, any canceled checks, any bank transfers, any written agreement, anything. She had nothing, just her word. We declined to pay. She never pursued it further. Here's what you need to know about personal loans from family or friends. First, without a written agreement, promissory note, or documentation of the loan, it's nearly impossible to legally enforce. Second, even if the loan is documented, you're only personally liable if you co-signed or guaranteed it. Otherwise, it's a claim against the estate, not against you individually. Third, be very cautious about making any payments on alleged loans. In some states, making a payment can be seen as acknowledging the debt, which might create legal liability where none existed before. Fourth, if someone claims your deceased spouse owed them money, ask for documentation. Don't accept verbal claims. You have the right to verify the debt before paying a cent. And fifth, if the alleged debt is large, consult with an attorney before making any decisions. Don't let family pressure or guilt push you into paying money you may not owe. From an emotional standpoint, these claims are incredibly painful because they involve people, often people you trust. You don't want to be seen as dishonoring your spouse's debts or being difficult with family, but grief and family relationships cannot override your need to protect your financial security. You have the right to ask for proof, you have the right to verify claims, and you have the right to refuse payment if the debt cannot be substantiated. You can do this too. One firm question, can you show me the documentation, can protect you from paying thousands you may not owe. And now, let's talk about the cruelest financial trap of all, the one that happens when you're planning your spouse's funeral, when you're too heartbroken to think about money. When Margaret's husband died, she walked into the funeral home in a fog of grief. The funeral director was kind, sympathetic, professional. He guided her through the arrangements. We want to honor your husband properly, he said. We have several packages. Our bronze package is $8,400, silver is $12,800, and our gold package, which includes our finest casket, premium burial vault, enhanced service, is $18,500. Margaret couldn't think. She couldn't process numbers. She just wanted her husband to have a dignified farewell. The silver package, she whispered. Over the next hour, the funeral director suggested additions. You'll want our grief support package for $800, the video tribute service for $600, the premium memorial cards for $340, the online obituary enhancement for $450. Margaret nodded to everything. She signed papers she didn't read. The final bill was 16,780. It wasn't until 3 months later, when Margaret was reviewing her finances, that she realized what she'd spent: nearly $17,000 for a funeral, money she desperately needed to live on. And here's the heartbreaking truth: most of what Margaret paid for was unnecessary markup and emotional manipulation. The funeral industry is largely unregulated in terms of pricing, and it preys on grieving families who are in no emotional state to negotiate or comparison shop. Funeral directors use phrases like honoring your loved one and paying proper respects to make you feel that spending less would be disrespectful, but your spouse would not want you financially destroyed to pay for an expensive funeral. From my work with widows and widowers, and from my own experience losing Eleanor, I've learned that funerals can be simple, dignified, and affordable. They don't need to cost $15,000 or $20,000. Here's what you need to know about funeral costs. First, under federal law, the funeral rule, funeral homes must provide you with an itemized price list. You have the right to select only the services and products you want. You don't have to buy a package. Second, you don't need the most expensive casket to honor your loved one. Caskets can range from $1,000 to $10,000 or more. The expensive ones don't provide any additional functional value. A simple, dignified casket is equally respectful. Third, many funeral homes charge service fees or facility fees that are pure markup. Question every fee. Ask what it covers. Fourth, you don't need embalming in most cases. Embalming is only required if there's an extended delay before burial, or if the body is being transported across state lines. It can cost $500 to $900, and it's often completely unnecessary. Fifth, burial vaults are often required by cemeteries, but you can buy them from third-party vendors for much less than the funeral home charges. And sixth, consider cremation. A direct cremation can cost $1,000 to $2,500 compared to $7,000 to $12,000 or more for a traditional burial. When Eleanor died, I was a lawyer who specialized in protecting people from financial exploitation, and even I was vulnerable in the funeral home. The director was so kind, so understanding, that I almost bought services I didn't need. But then I stopped myself. I thought, would Eleanor want me to spend $18,000 on a casket, or would she want me to keep that money for our grandchildren's education? I knew the answer. I chose a simple but dignified service. The total cost was $4,200, and I honored Eleanor every bit as much as I would have with the $18,000 package. Here's what you need to do when planning a funeral. First, if possible, bring a trusted friend or family member with you to the funeral home, someone who's not in the fog of grief and can think clearly about costs. Second, ask for the itemized price list and review it carefully. Don't accept packages. Select only what you actually need. Third, get quotes from multiple funeral homes. Prices can vary dramatically, and shopping around can save thousands. Fourth, consider pre-planning your own funeral now, while you're clear-headed. When you're the one dying, your family won't have to make these decisions under duress. And fifth, remember this: a simple funeral can be every bit as meaningful and dignified as an expensive one. Your love for your spouse is not measured in dollars spent. You can do this too. One moment of clarity, one decision to choose what you need rather than what you're pressured to buy, can save you $10,000 or more. So, those are the 6 financial traps that widows and widowers face after losing a spouse: credit card debts you don't owe, medical bills you're not responsible for, joint accounts that creditors can't touch, property obligations you can manage or walk away from, personal loans that can't be proven, and funeral expenses that are wildly inflated. Every single one of these traps preys on your grief, your confusion, and your desire to do the right thing. But here's what I need you to understand: protecting yourself financially is doing the right thing. Your spouse would want you to be financially secure. They would want you to question illegal debts, challenge improper bills, and refuse to pay money you don't legally owe. Now, here's what you need to do. First, if you're facing any of these situations right now, don't panic. Take a breath. You have time to respond properly. Second, don't make any payments on debts or bills until you've verified that you're legally responsible. Once you pay, it's much harder to get the money back. Third, Request documentation for everything. Don't accept verbal claims, get it in writing. Fourth, consult with an attorney who specializes in elder law or probate. Most of us offer free consultations and we can help you understand your rights. Fifth, know that you're not alone. Every widow and widower faces these pressures, and there are advocates like me who are here to help you. And sixth, be kind to yourself. You're navigating one of the hardest experiences of human life. If you make a financial mistake, it's okay. You can recover. But knowing your rights can help you avoid those mistakes in the first place. Here's what I want you to understand. Grief is hard enough without financial exploitation. You deserve to mourn without being hunted by debt collectors. You deserve to honor your spouse without being manipulated by funeral homes. And you deserve to protect the financial security you and your spouse built together. I'm 72 years old. I lost the love of my life 5 years ago. And I still miss Eleanor every single day, but I'm grateful that I knew my rights, that I could protect our assets, and that I didn't let companies exploit my grief. I want that same protection for you. If this video helped you, please share it. Share it with a friend who lost a spouse. Share it with a support group. Share it on social media, because this information could save someone from financial devastation during the worst time of their life. And tell me in the comments, are you facing any of these financial traps right now? You don't have to share details, but knowing you're not alone can help, and your story might give someone else the courage to speak up. I'm Charles Wellington. I've been doing this work for 38 years, and I'm not going to stop fighting for widows and widowers as long as companies keep exploiting them. You deserve to grieve with dignity. You deserve financial security, and you deserve to know that there are people who will stand beside you. Thank you for watching. Now go protect yourself and honor your spouse by safeguarding what you built together.